Okay. Ashwini Kumar, if I can come to you, do you agree with what Dr. Rajiv Jaydevan is saying? Is there intent on one end and the implementation on the other, and the distance between the two is quite far?
There is a thin line. What is to be seen? That an improper, unskilled person not having the efficiency to treat that particular patient is carrying out any medical procedure and person dies. In that eventuality only, section 106 of BNS applies. Why? Mens rea and intent is that there are two important components of a law. The duty or obligation of care in finding out whether to undertake an unique case or not. This is one. Supposingly, I'm a law student. If I'm not able to do any complex issue of legal or any important complex issue, then I should say, so sorry, I don't have expertise on this. So question arises, if there is a proper care, person has skilled, person is not negligent, then in that case, the law itself says, section 106 itself says, that there is no 106. Earlier also, even if you see section 304A, there was a medical negligence, though it was a punishable for 2 years, and also the civil liability, tortious liability, that was there. Here, just has been increased for 5 years, that too in that case where the reckless or thoughtlessness behavior, which does not constitute culpable homicide and person died. Why I will say, one person visited to Vedanta Lucknow, you must have read in the social media, then immediately doctors started surgery have to be done. And when he visited to the registered medical clinic, gas hua hai. So 3 lakhs rupees which he was about to deposit in a big multinational hospital or corporate hospital, he was just cured for 1500 rupees. So don't you call it an attempt by a person who is there just to make money. Yani, patients are not the object. Why? When an accountant makes a mistake, there will be a loss of money. But if a doctor makes a mistake, there is a threat of losing a life. And this law makes a line where we have to be cautious enough while treating a patient. Over to you. This is the law says.
Okay, Dr. Sanjeev Bagai. Now let me ask you this question. You were there on the panel when we were discussing the deadly Delhi fire where infants were killed. I'm using the word infants were killed, they had died. And eventually what we got to know was the doctors who were appointed there were not qualified enough. They were not doing the job that they were meant to do. Negligence would be just one word, but nonetheless, it was negligence. It was far beyond negligence as well. Now, how do you differentiate? The law is very clear. It's medical negligence. You have Dr. Rajiv Jaydevan and you have yourself who believe that this is not about medical negligence. This is going far beyond and creating an atmosphere of fear, paralyzing the doctors. But there are two extremes to this as well. You do have acts of negligence by doctors that have serious ramifications, including deaths. And we have seen it play out time and again in India. Latest being the Delhi fire cases, that was, at least in the intensity of the reports that have been reported. And now, why equate the two? Is it really that paralyzing? Aren't these for two different cases?
Okay, 4 very important points, and I think it's important to differentiate the terminologies and the understanding and perception. It's important to differentiate and understand what medical negligence is versus medical malpractice. Medical negligence is a deliberate, established act of omission or commission. It's a deviation from a standard protocol or procedure which a common doctor would do for that disease or illness, causing injury or death. Malpractice consists of various types, including injury, malpractice of intent, malpractice of financial needs, referrals, cuts, commissions, employing unqualified people in the hospital, and so on. Here, the difference here is that the doctors, just allow me exactly 60 seconds, doctors are not routine service providers.
Go ahead, take your time.
Doctors are people who spend the better part of their youth and their early adult life just in academics and training. we spend upwards of 12 years to become a specialist and another 10 years to further advance our skills. And let me explain, in these 20, 25 years after leaving school, life is not easy. There are boards, there are state boards, there are medical review forums, and there are various other platforms where cases of suspected medical negligence or alleged medical negligence are scrutinized. A patient cannot decide whether it's medical negligence. Neither can a police or a local police station. We cannot precipitate an environment of fear, anxiety, or uncertainty in a doctor's mind. Doctors have to take split-second decisions to save human lives. I'm in pediatrics and pediatric nephrology for the last 30, 35 years, and we know what we go through every day, every minute. The fallout of this is, if there is a fear, if there is a cause of fear in doctors' minds, they will stop taking critical cases. They will take cold cases. The cost in terms of healthcare to the patient will increase because the doctors will practice what we call as defensive medicine. There will be more number of tests, more number of investigations, and the ultimate burden is going to be on a patient.
Okay.
If a doctor does a deliberate act, surgery on a wrong limb, surgery from an untrained person, 100% that person has to be held accountable, liable. Whatever is under law, 100% done. But there has to be a differentiation, a genuine error of judgment, a genuine differentiation in line of treatment is not negligence or malpractice. Remember, doctors work only in the best and only in the best interest of patients. A cause of death is a natural cause in many cases. Doctors cannot save every human life. Our endeavor, our faith, our trust is with the patients. Laws like this will create further distrust between doctor-patient relations.
You made your point, sir. Okay, Aditya Pratap, before I come to you, let me just allow me a few minutes. Give me 2 minutes, Aditya Pratap. Let me just go back to Ashwini Kumar. What would you say, Mr. Ashwini Kumar, to what Dr. Sanjeev Bagai has just said, that the patients and the police is not capable to decide whether it is a medical negligent act or not?
But the subsequent medical treatment, that is what the law says. When there was no BNS, no 106 subclause 1, then there was a 304A. If you approach to the National Consumer Commission or State Consumer Commission, subject to what kind of amount you are seeking, there has to be a subsequent opinion of a doctor. And if not, then there has to be the medical jurisprudence of a reputed institution like All India Institute of Medical Science, whether the medicine, whether the treatment which has been provided, those are in consonance, or those are for the treatment of the patient's the disease, what he is having. That is why there is a settled law. The Supreme Court has stated that each and every health practitioner has a responsibility to act with an affordable amount of care and skill. As I said, if I don't have any knowledge of a mining law and I take up a matter of mining law, then your matter will definitely, how will I justify taking that matter? So that is why the obligation to seek is the first component under the medical jurisprudence. Then prognosis is the second component. Then patient's delicacy and secrecy in the patient must not be neglected. This is one. Giving medical aid does not amount that you have a right, you have a knowledge for treating the cases which have to be dealt by the statesman like Mr. Dr. Bagai. Not each and every person. मुझे नहीं पता है अगर कि मुझे क्या इलाज करना है, and I start putting the syringe and cutting things, that is to be taken into account. और इसीलिए medical negligence की जो first foremost जो accountability है, that has to be by virtue of a medical research. And that research is not from the Google, that research from the institutions, that research based on the doctors who have expertise over that. Over to you.